Welcome to this crash course on the federal rules of evidence, the backbone of what gets in and what stays out during trial. Whether you're preparing for mock trial, a bar exam, or real-world litigation, mastering these rules is critical for courtroom competence. Let's begin with Article 1, General Provisions. Rule 102, Purpose of the Federal Rules of Evidence. These rules should be construed so as to administer every proceeding fairly, eliminate unjustifiable expense and delay, and promote the development of evidence law to the end of ascertaining the truth and securing a just determination. What it means in legal terms. Rule 102 sets the interpretive lens through which all evidentiary rules must be viewed. It's the guiding philosophy of the Federal Rules of Evidence, FRE. In practice, this means fairness in proceedings. Parties must have a fair chance to present and challenge evidence. Efficiency. Courts should avoid unnecessary technicalities that waste time or inflate costs. Truth-seeking. The primary goal is to ensure that decisions are based on reliable, probative evidence. Judicial discretion. Judges are encouraged to interpret the FRE flexibly, not rigidly, to promote justice. It doesn't prescribe specific admissibility standards like hearsay or relevance. Rather, it governs how all other rules should be applied and interpreted. In United States v. Elizabeth Holmes, federal prosecutors presented evidence that Holmes knowingly misled investors and patients about the capabilities of Theranos' blood testing technology. At one point, Holmes' defense objected to the inclusion of emails and reports that they claimed were misleading or taken out of context. The judge had to decide whether allowing the jury to see these documents would be fair under the FRE, particularly Rule 403, balancing prejudice, but also had to interpret the spirit of the rules under Rule 102. The judge allowed the evidence, emphasizing that it promoted truth-finding as it showed what investors were told. The process was fair. Both parties had access to the documents. It did not cause undue delay or prejudice that would outweigh its probative value. In this way, Rule 102 helped guide the court in balancing technical objections against the broader goals of justice and truth. Next, judicial notice under Rule 201. Courts may accept certain facts as true without requiring formal evidence, like the time the sun rises or the location of a city, but only if the fact is not reasonably disputable. Rule 201, judicial notice of adjudicative facts. Rule 201 allows a federal court to accept certain adjudicative facts as true without requiring evidence, but only if the fact is not subject to reasonable dispute and is either A, generally known within the trial court's jurisdiction, or B, can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned. This rule applies only to adjudicative facts, facts about the case itself, e.g. location, time, physical laws, and not legislative facts like broad policy considerations or social science data. Once a court takes judicial notice, in civil cases, the jury must accept the fact as true. In criminal cases, the jury may accept the fact as true, but isn't required to. Why it matters. Judicial notice is a tool to save time, avoid unnecessary evidence, and focus the trial on facts that are actually disputed. For instance, instead of calling a witness to testify about the sunrise time on a specific day, the court may just take judicial notice using a government almanac. Real-life example, United States v. Gould, 536 F2D 216 8th Sur 1976. In U.S. v. Gould, the defendant was accused of possessing firearms as a convicted felon. The issue was whether he knowingly transported the guns across state lines, a required element for federal jurisdiction. The prosecution introduced no direct evidence of where the guns had been manufactured. However, the judge took judicial notice that certain brands of guns were not manufactured in the state where the crime occurred. The court relied on manufacturer catalogs and federal registries as sources whose accuracy cannot reasonably be questioned. This allowed the court to conclude that the guns necessarily traveled in interstate commerce, satisfying the federal jurisdiction element. The appellate court upheld this use of judicial notice as appropriate and efficient. provided the defense had the opportunity to challenge the fact, which they did not. In civil cases, presumptions shift the burden of production, but not persuasion. If a party can show a presumption applies, the burden is on the opponent to rebut it. But federal courts defer to state law on presumptions when state law governs the claim. Presumptions in civil cases, Rule 301. In a civil case, unless a federal statute or these rules provide otherwise, the party against whom a presumption is directed has the burden of producing evidence to rebut the presumption. But this rule does not shift the burden of persuasion, which remains on the party who had it originally. Key concepts: presumption, a legal inference or assumption that a fact exists based on the known or proven existence of another fact. Example: if a letter was properly mailed, the law presumes it was received. Burden of production, the obligation to produce sufficient evidence to rebut a presumption. Burden of persuasion, the obligation to convince the fact finder of the truth of a fact in issue. This never shifts under Rule 301. So when a presumption applies, it shifts the burden of production to the opposing party, who must offer some evidence to counter it. It does not shift the burden of persuasion, which remains with the party that originally bore it, typically the plaintiff. State law and federal deference, Rule 302 of the FRE provides that in a civil case, state law governs the effect of a presumption regarding a claim or defense for which state law supplies the rule of decision. This means that in diversity cases where federal courts hear state law claims, the court applies the state's law presumptions, not the federal standard. This preserves state-level legal policies and evidentiary balances. Real-life example: Erie R.R., Comer v. Tompkins, 304 U.S. 64, 1938. Although Erie isn't about presumptions per se, it established a principle that federal courts must apply state substantive law in diversity cases. This includes presumptions because they are often outcome determinative and therefore substantive. A more specific example is real-life example Dick v. New York Life Inns Co. 359 U.S. 437, 1959. In this case, a life insurance policyholder disappeared and was presumed dead under state law, Louisiana, which had a statute stating that a person absent for 7 years without explanation is presumed dead. The insurance company challenged the presumption in federal court. Under Louisiana law, the presumption of death shifted the burden of production to the insurer to show that the person was still alive. Because this was a diversity case, the federal court applied Louisiana's presumption, not the federal approach under Rule 301. The court held that the insurer failed to rebut the presumption and the policy was payable. This is a classic example of Rule 302 in action, where state presumptions control the outcome in a federal court civil case because the underlying law is state law. Rules 401 to 403 test the heart of admissibility. Is it relevant? That is, does it make a fact more or less probable? If so, the court then weighs whether the relevance is outweighed by risks, prejudice, confusion, or waste of the time. Rules 401 to 403. The gatekeepers of admissibility. Rule 401 sets the threshold for admissibility. Evidence is relevant if A, it has any tendency to make a fact more or less probable than it would be without the evidence, and B, the fact is of consequence in determining the action. This is an intentionally low bar. Almost anything that helps the jury decide a material issue is relevant. But relevance is necessary, not sufficient for admissibility. This rule provides the basic principle: relevant evidence is admissible unless any of the following provides otherwise. The U.S. Constitution, a federal statute, these rules, or other rules prescribed by the Supreme Court. So if it's relevant, it's admissible, unless another rule like hearsay or privilege excludes it. Even if evidence is relevant, the judge may exclude it if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. In other words, Rule 403 gives judges discretion to prevent a trial by distraction or trial by emotion. The key phrase is substantially outweighed. The default favors inclusion unless the downside is significant. Now let's look at a real-life example. State v. George Zimmerman in 2013. This case involved the fatal shooting of 17-year-old Trayvon Martin by Neighborhood Watch volunteer George Zimmerman. Zimmerman claimed self-defense. The prosecution wanted to introduce photos and text messages from Martin's phone showing he had engaged in fights before and had texted about buying a gun. They argued this was relevant to Martin's character for aggression, potentially supporting Zimmerman's account of the confrontation. The judge excluded this evidence under Rule 403, ruling that the risk of unfair prejudice and jury confusion substantially outweighed the evidence's probative value. The judge was concerned that the jury might focus on Martin's character rather than the facts of the confrontation and be improperly swayed by irrelevant details of Martin's past. Thus, even though the evidence was arguably relevant under Rule 401, it failed the Rule 403 balancing test. Rule 501 tells us privileges are mostly shaped by common law, unless otherwise directed by statute or constitution. Think attorney-client, doctor-patient, and yes, even spousal privilege, the United States Constitution, a federal statute, or rules prescribed by the Supreme Court. In civil cases, state law governs privilege if state law supplies the rule of decision on a claim or defense, such as in diversity cases under Erie Doctrine. Unlike other evidence rules, which are codified in specific, Rule 501 is open-ended and dynamic. It defers to judicial development of privilege law, meaning courts build and refine privileges case by case based on evolving public policy and societal values. Some of the recognized federal privileges shaped by common law include attorney-client privilege, spousal testimonial privilege, marital communications privilege, clergy penitent privilege, and psychotherapist patient privilege, which was recognized by the Supreme Court in Jaffe versus Redmond. But not all confidential communications are privileged, only those that society deems so essential that even the pursuit of truth should not override them. For instance, in Jaffe versus Redmond, a police officer named Redmond shot and killed a man during a call. The family sued under Section 1983 for civil rights violation. During discovery, plaintiffs sought therapy session notes from Redmond's licensed clinical social worker. Redmond refused, claiming psychotherapist patient privilege. The Supreme Court, applying Rule 501, held that federal courts recognize a psychotherapist patient privilege. It reasoned that the common law evolves based on reason and experience, and mental health treatment depends on privacy. The privilege was deemed essential to public good, and the notes were protected from disclosure. This case solidified a major privilege under Rule 501 that hadn't been explicitly stated in any statute, demonstrating how the rule allows courts to develop new privileges based on contemporary values and needs. Rules here guide how witnesses testify, how they can be cross-examined, and when leading questions are appropriate. Importantly, Rule 611 gives judges discretion to maintain order and protect witnesses from harassment. The court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to 1. Make those procedures effective for determining the truth, 2. Avoid wasting time, and 3. Protect witnesses from harassment or undue embarrassment. Leading questions should not be used on direct examination, except as necessary to develop the witness's testimony, such as with children or nervous witnesses, and when examining a hostile witness, an adverse party, or a witness identified with an adverse party. Judges have broad authority to decide how questioning is conducted. They can intervene to protect vulnerable witnesses, prevent badgering or repetitive questioning, and control time to keep trials moving efficiently. Parties have a right to cross-examine adverse witnesses, but the judge may still step in if the questioning becomes harassing or confusing. Leading questions are generally not allowed on direct but are expected during cross-examination or when dealing with hostile or evasive witnesses. Let's look at a real-life example. People v. Larry Nassar in 2018. Larry Nassar, the former USA gymnastics doctor, was convicted of sexually abusing over 150 young athletes. During the sentencing hearing in Michigan State Court, numerous survivors gave victim impact statements. While this wasn't a federal trial, the principles of Rule 611 were invoked by the judge in a manner consistent with federal evidentiary values. The judge allowed extended, uninterrupted statements from survivors to support effective truth-finding and protect vulnerable witnesses. When Nassar's defense attorney objected to the volume and tone of victim testimony, the judge rejected the objections, citing the court's responsibility to protect the dignity of witnesses and allow them to be heard. The judge maintained courtroom decorum, restricted unnecessary cross-questioning of survivors, and limited defense maneuvering that could cause emotional harm. While this wasn't a FRE 611 case directly, it mirrors how federal judges apply Rule 611 to balance due process with humane treatment of witnesses, especially those in emotionally charged or traumatic cases. Under Rule 702, expert witnesses may testify if their knowledge will help the jury and their methods are reliable. Think Daubert standard here: relevant, reliable, and rigorously tested. Rule 702, testimony by expert witnesses. A witness who's qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if the expert's scientific, technical, or specialized knowledge will help the trier of fact to understand the evidence or determine a fact in issue. The testimony is based on sufficient facts or data. The testimony is the product of reliable principles and methods. The expert has reliably applied the principles and methods to the facts of the case. Rule 702 ensures experts don't mislead juries with opinions based on shaky science or untested theories. It codifies the Daubert standard, established in Daubert v. Merrill Dow Pharmaceuticals, Inc., 509 U.S. 579, 1993, which sets a gatekeeping function for trial judges. Under Daubert, courts consider several non-exclusive factors to determine reliability. Whether the theory or technique can be tested, whether it has been peer-reviewed and published, its known or potential error rate, the existence and maintenance of standards controlling its operation, whether it has general acceptance in the relevant scientific community. The trial judge must assess not only whether the expert is qualified, but also whether the methodology is scientifically valid and applied correctly to the facts of the case. A real-life example is General Electric Company Joiner, 522 U.S. 136, 1997. A man named Joiner sued GE, claiming that his cancer was caused by PCB exposure at work. He presented expert witnesses who testified that PCBs caused his type of cancer, citing studies on mice. The trial court excluded the expert testimony, ruling that the studies did not directly support the expert's conclusion. The methodology was not reliably applied. The appellate court reversed, applying a more lenient standard. The Supreme Court reversed the appellate court, upholding the trial judge's exclusion and reinforcing the idea that trial judges have broad discretion under Rule 702 and Daubert to determine whether an expert's methodology is valid and properly applied. This case confirmed that judges must act as gatekeepers. They are not required to admit expert testimony just because the expert is credentialed. Perhaps the most complex area, hearsay, generally barred under Rule 802, has dozens of exceptions. If an out-of-court statement is used to prove the truth of what it asserts, it's hearsay, unless it fits one of the exceptions in Rules 803 to 807. Rule 802. The rule against hearsay. Hearsay is a statement that the declarant does not make while testifying at the current trial or hearing, and that a party offers in evidence to prove the truth of the matter asserted in the statement. Hearsay is not admissible unless A federal statute, the federal rules of evidence, especially rules 803 to 807, or other Supreme Court rules say otherwise. Hearsay is typically barred because the declarant is not under oath. The opposing party cannot cross-examine the declarant. The jury cannot assess the demeanor or credibility of the person who made the statement. The goal is to preserve the integrity of the fact-finding process by limiting unreliable secondhand statements. Rules 803 to 807, exceptions to the hearsay rule. Rule 803 applies even if the declarant is available. Excited utterance, e.g., someone shouts he's got a gun during a robbery. Present sense impression, e.g., he's speeding past me now, said during a 911 call. Business records, medical diagnoses. Rule 804 applies when the declarant is unavailable. Dying declarations, statements against interest, former testimony. Rule 807, residual exception allows hearsay that doesn't fit neatly into 803 or 804, but has equivalent guarantees of trustworthiness and is highly probative. A real-life example is Crawford v. Washington, 541 U.S. 36, 2004. Michael Crawford was on trial for stabbing a man he claimed tried to rape his wife. Prosecutors introduced a recorded statement by Crawford's wife to police, which undermined his self-defense claim. The wife did not testify at trial, invoking spousal privilege, so the statement was hearsay. The prosecution claimed it fit the exception for statements against interest or the residual exception. The court held that even if the statement met a hearsay exception, it was inadmissible under the Sixth Amendment Confrontation Clause, which guarantees a defendant the right to confront witnesses against them. The court ruled that testimonial hearsay, statements made during police interrogation or with the expectation they'll be used in prosecution, is barred unless the witness is unavailable and the defendant had a prior opportunity to cross-examine them. This case reshaped the constitutional boundaries of hearsay exceptions, especially in criminal law. Before evidence can be admitted, it must be shown to be what it claims to be. Rule 901 requires proof of authenticity, and Rule 902 outlines categories that are self-authenticating, such as certified public documents and newspapers. Rule 901, requirement of authentication or identification. To satisfy the requirement of authenticating or identifying an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. What this means. Before evidence like a text message, email, photo, weapon, or document can be admitted in court, it must be authenticated. Someone must show it's genuine and not tampered with, forged, or misattributed. Common methods of authentication, Rule 901B, testimony of a witness with knowledge, e.g., I took this photo, comparison by an expert, or the jury with a known sample, e.g., handwriting. Distinctive characteristics, e.g., unique markings on an object. Chain of custody for physical evidence. Rule 902, self-authenticating evidence. Certain types of documents are considered so inherently trustworthy that they do not require extrinsic evidence of authenticity. Examples under Rule 902, certified public records, e.g., birth certificates, court records, official publications, e.g., federal or state government reports, newspapers and periodicals, trade inscriptions, e.g., labels affixed to products, notarized documents, electronic records certified by qualified personnel, added by amendments for digital age, because they come from reliable, verifiable sources. These items authenticate themselves and can go straight into evidence unless challenged for a specific reason. Real life example, United States versus Safavian, 435F Sup 2 D36 DDC 2006. Case background, David Safavian, a former government official, was charged with obstruction and making false statements during an investigation into lobbying trips involving Jack Abramoff. A key part of the prosecution's case was emails sent and received by Safavian, offered to prove what he knew and when he knew it. How Rule 901 applied. Defense argued that the emails were not properly authenticated, questioning their origin and integrity. The government used Rule 901B4 authentication based on distinctive characteristics. The email headers contained Safavian's address. The content referred to matters only he would discuss. Context matched his known work and communications. The court held that this circumstantial evidence was enough for Rule 901 and allowed the emails to be presented to the jury. This case illustrates how digital evidence, while often challenged, can be authenticated through contextual clues and internal characteristics, even without direct testimony from the sender. Need to prove the contents of a writing? The best evidence rule under Rule 1002 applies. You must use the original or a duplicate unless you meet an exception. Rules 1004 to 1008 help guide what counts when the original isn't available. Best evidence rule. Rule 1002. An original writing, recording, or photograph is required in order to prove its content, unless these rules or a federal statute provides otherwise. What this means: if a party wants to prove the contents of a document, e.g. a contract, letter, text message, video, or audio recording, they generally must produce the original or a valid duplicate, unless an exception applies. This rule is meant to prevent fraud or misquotation, ensure accuracy of the evidence, and maintain the integrity of key documents. The best evidence rule does not apply when you're not trying to prove the contents of the document, just its existence, or when a witness recalls events independently. Related rules and exceptions. Rule 1003, duplicates. A duplicate is admissible to the same extent as the original unless there's a genuine question about the original's authenticity, or it would be unfair to admit the duplicate. Rule 1004, when original is not required. The original is not required if it's lost or destroyed, not in bad faith. It can't be obtained through judicial process. The party has control of the original and fails to produce it, or the document is not closely related to a controlling issue. Rules 1005 to 1008. 1005. Public records may be proven with a certified copy. 1006. You can use summaries of voluminous records if originals are available for inspection. 1008. In jury trials, the jury decides whether the original exists, is genuine, or is required under the rule. Real life example: Seiler vs. Lucasfilm, Linimid, 808F, 2D 1316, 9th Series 1986. Case background: an artist, Seiler, sued Lucasfilm for allegedly copying his artwork when creating the Imperial Walkers in Star Wars: The Empire Strikes Back. Seiler claimed his original drawings were the basis for the designs. What happened? Seiler did not produce the original drawings he claimed were copied. Instead, he submitted recreations drawn from memory after litigation had begun. The court held this violated the best evidence rule. The original was crucial to proving exact content. The recreations weren't admissible substitutes under Rule 1002 or Rule 1004. No adequate explanation for missing originals. The court ruled in favor of Lucasfilm, and the case was dismissed. Finally, Article 11 covers applicability, amendments, and the official title. Rule 1101 clarifies these rules apply broadly in federal proceedings, but not, for example, to grand jury hearings or extradition proceedings. Rule 1101, applicability of the rules. Rule 1101 clarifies the scope of the federal rules of evidence. Generally, these rules apply to all federal civil and criminal trials, bankruptcy, and admiralty proceedings in contempt hearings, except summary contempt. But importantly, Rule 1101D excludes the application of evidence rules in certain proceedings. These rules, except for rules on privilege, e.g. Rule 501, do not apply to preliminary questions of fact under Rule 104A, grand jury proceedings, extradition or rendition proceedings, bail hearings, sentencing, probation, or supervised release revocation, issuance of arrest, search warrants, and pretrial detention determinations. Why this matters. The federal rules of evidence are designed for formal courtroom adjudication. where procedural fairness and adversarial testing are paramount. In contrast, some proceedings, like grand jury or sentencing, serve investigative, administrative, or summary functions. In those settings, judges and legal actors need flexibility and aren't bound by the strict evidentiary rules used in trial. The only exception that consistently applies is the law of privilege, which still protects confidential communications in all federal proceedings, even when other evidence rules don't apply. Real-life example, United States versus Calandra, 414 U.S. 338, 1974, case background. A grand jury was investigating possible federal crimes. The defendant, Calandra, was subpoenaed to testify, but he refused to answer certain questions on the grounds that the underlying search warrant used to seize evidence against him was unconstitutional. Legal question. Can a witness in a grand jury proceeding invoke the exclusionary rule, which generally bars illegally obtained evidence? Supreme Court ruling. The court held that evidentiary rules, including the exclusionary rule, do not apply to grand jury proceedings. This is in line with what would later become Rule 1101D2. The court emphasized that a grand jury's function is investigative, not adjudicatory. Applying exclusionary rules would undermine the flexibility and efficiency of the grand jury process. Thus, even if the search was illegal, the grand jury could still hear the evidence. That's your 10,000-foot overview of the federal rules of evidence. To win cases, you don't just need facts. You need to know which facts the court will actually hear. So study hard, object wisely, and remember, evidence is everything. Title, Federal Rules of Evidence. Know them. Use them. Win. On-screen text.